You allegedly was called, came back with a weapon, allegedly that weapon in a home, committed cold-blooded murder.
This is not about revenge. It's about making sure no one goes through the same torment, the same humiliation, or the same emotional damage I have.
Shelton M. Kincaid, a longtime youth basketball coach in Madison, Wisconsin, was accused of assaulting two girls he coached during the 1990s. One of the survivors testified that the abuse began in 1997 and continued for several years, often taking place at Kincaid's home or during out-of-town basketball trips. Another victim reported a separate assault in 1992. Both girls were connected to Kincaid through the Madison Spartans Youth Basketball Club and the Dane County Neighborhood Intervention Program. In 2016, following their testimonies and a detailed trial, a jury found Kincaid guilty of repeated assault of a child and second-degree sexual assault of a child.
By all accounts, Mr. Kincaid is a decent human being. If a kid needs shoes, he got a kid's shoes. If a kid needed a meal, he got a meal.
I'm asking you for justice too. I'm asking you to hold this defendant accountable once and for all for what he did to me.
We, the jury, find the defendant, Shelton Kincaid, guilty of repeated sexual assault.
He was sentenced to 13 years in prison with eligibility for parole after serving nearly 11. After Kincaid's conviction, one of the victims filed a civil lawsuit against the Amateur Athletic Union, AAU, claiming the organization had been negligent in allowing him to coach, despite a prior conviction for child assault in 1990. The suit argued that the AAU failed in its duty to properly screen and supervise coaches. However, in 2023, the Wisconsin Supreme Court dismissed the case, ruling that the claim was barred by the statute of limitations, which requires such lawsuits to be filed within 3 years of the victim turning 18. The court clarified that the extended timelines available for criminal charges of sexual assault of minors did not apply to third-party negligence lawsuits. In February 2024, Shivis Whipple, Dean of Students for Youngstown City Schools and East High School basketball coach, was caught on a doorbell camera physically assaulting his daughter. The footage showed Whipple confronting her outside her boyfriend's home late at night, pushing her into a car and striking her, actions he later defended as discipline. However, authorities determined the behavior crossed the line into abuse. He was arrested and charged with assault and criminal endangerment. Initially pleading not guilty, Whipple faced trial, but the case resulted in a mistrial in October. He later agreed to a plea deal in November, admitting guilt to amended charges of assault and criminal damage.
Accountability is not just necessary, it is vital for me to begin healing. This is not about revenge. It's about making sure no one goes through the same torment, the same humiliation, or the same emotional damage I have.
At sentencing, the victim delivered emotional testimony describing the lasting impact of the incident and calling for accountability, not revenge. The court, after reviewing the video evidence, rejected claims that Whipple's intent excused his actions.
I did not know my value, being there around those kids and just being able to mentor them and be an example for them. I feel like I failed them.
Whipple expressed remorse, apologizing to his daughter and the community.
If this video was not obtained, I need you to understand that his abusive and controlling behavior would still be going on today.
Although he may have not gone about it the right way, he never had any intention of harming her. He went there with good intentions.
I've looked at the tape, and I've probably looked at it more than I care to look at it, because I've stopped it, went back, stopped it, went back, stopped it, went back. And all I can say is that conduct is vile and reprehensible.
Judge Jeffrey Adler condemned the behavior as vile and reprehensible, sentencing Whipple to 90 days of electronically monitored house arrest, 3 years of probation, and a $1,000 fine. Following the incident, he was placed on administrative leave, and his contract with the school district was not renewed. In May 2012, Erica Nato Campbell, a Portland resident and granddaughter of a prominent local developer, alleged that she was assaulted by Charles McGee and Aubrey Lamont Dixon after a night out. The three had been socializing as part of a leadership program, visiting a bar, a strip club, and eventually ending up at McGee's home in southeast Portland. Nido Campbell said both men engaged in non-consensual conduct. Though she didn't report the incident immediately to law enforcement, she later disclosed it to friends, family, and a therapist. The case came back into the spotlight in 2018 when McGee announced his candidacy for a seat on the Multnomah County Commission, prompting Nido Campbell to go public with her story. That same year, a grand jury indicted both men on multiple charges of sexual assault. The trial began in March 2019, with both McGee and Dixon choosing a bench trial before Judge David Reese rather than a jury. The prosecution's case relied on Nido Campbell's testimony and the people she had confided in, as no physical evidence or witnesses were available. The defense questioned her credibility and motives.
I want to start out by thanking counsel for their professionalism, skill, and diligence in what has been a difficult and stressful trial for all participants. I have carefully reviewed and analyzed all the evidence in this case. I've reviewed every exhibit that was received. I reviewed my notes of all testimony. I've considered and reconsidered all the testimony that I've heard. I find that I cannot conclude to a moral certainty that the defendants are guilty of the crimes they are charged with. Thus, the state has not satisfied the burden of proving the defendants are guilty beyond a reasonable doubt. My verdict is not guilty on all 7 counts alleged against Charles. And my verdict is not guilty on counts 3, 4, 5, and 7 against Aubrey Dixon. The defendants are released from their reporting obligations to pretrial reporting services. And they are successful. Justice!
After reviewing all testimony and evidence, Judge Reese ruled that the state had not proven guilt beyond a reasonable doubt. On March 22nd, he found both men not guilty, clearing McGee of all 7 charges and Dixon of 4. The verdict led to emotional reactions in the courtroom and reignited public debate over how the justice system handles complex sexual assault allegations. In February 2011, Damon Morgan, a waiter at Marcello's Chop House in Albuquerque, was accused of secretly placing Valium into the wine of a female customer who happened to be a Bernalillo County prosecutor. The woman reportedly lost consciousness, prompting an investigation that led to Morgan's arrest. He was charged with aggravated battery and distribution of a controlled substance, and the incident drew media attention due to the serious nature of the allegations and the victim's role in the legal system.
These are entirely false accusations. I have never done any of the things I was accused of.
After years of legal delays, the case came to a turning point on December 19th, 2014, when a judge dismissed all charges against Morgan.
I would just attribute it to the delay based on trying to get a judge. Finally, we ran out of judges, and it had to be certified to the Supreme Court for the Supreme Court to appoint a judge, and that took a little bit of time.
The dismissal was based on a violation of Morgan's right to a speedy trial, as the prosecution had failed to bring the case forward in a timely manner. With the case dropped, Morgan was cleared of all criminal accusations related to the incident. Christina Peterson was elected as Douglas County probate judge in 2020, becoming the first African-American woman to hold the position. However, her time in office was quickly overshadowed by controversy. In 2021, the Georgia Judicial Qualifications Commission began investigating her for alleged misconduct. By 2022, Peterson faced 30 formal charges related to judicial behavior, including jailing a woman who tried to amend her marriage certificate and improperly pressuring her HOA board during a legal dispute.
I just don't have memories of my dad. I don't know who he is.
Did you go to this hearing with any idea that you may be going to jail?
No.
She also had charges against misusing courthouse security by allowing events after hours without proper clearance.
You cannot go in this building, and eventually she went in.
A judicial hearing panel reviewed the evidence in a 7-day proceeding beginning in late 2023 and ultimately found her guilty of systemic incompetence. The panel noted that she failed to take responsibility, repeatedly delayed petitions without cause, and frequently undermined courthouse operations with erratic and unprofessional conduct.
I'm the first African American female and Democrat. Yes. I was never celebrated or congratulated. On my day of swearing in, I was sworn in by Judge Emerson. I received my first JQC complaint.
In June 2024, the Georgia Supreme Court accepted the panel's recommendation and officially removed Peterson from office, citing her inability or unwillingness to perform the duties of a judge with integrity and impartiality. Just days before the ruling, Peterson was arrested in Atlanta following an altercation outside a nightclub. She was charged with simple battery against a police officer and felony obstruction. According to her legal team, she had been trying to protect another woman and was unaware the individual she pushed was a police officer. While these criminal charges were not part of her removal case, they further fueled public scrutiny. As of now, Peterson awaits a resolution in the criminal matter, while her removal from the bench marks a dramatic end to a historically significant but troubled judicial career. In March 2019, 29-year-old Lauren Ives was found dead inside her Cranston, Rhode Island apartment after police were tipped off by a friend of her ex-boyfriend, Michael Marapese. That friend had called 911, reporting that Marapese had confessed to killing Lauren. When officers entered her home on Bayview Avenue, they found signs of a violent struggle and discovered Lauren's body in the bedroom. She was pronounced dead at the scene by the fire department. Shortly after, Marapese, then 40, was arrested nearby. Detectives confirmed with the tipster that Marapese had admitted to the crime. He was charged with first-degree murder and ordered to be held without bail. At his March 14th arraignment, emotions ran high.
What is the allegation here?
Your Honor, on March 13, 2019, Cranston Police received information from Providence Police to check on the well-being of Lauren Issei at 245 Bayview Avenue. They had received information that Mr. Marapese, Michael Marapese, defended before you today, had told a friend he had killed his ex-girlfriend, Lauren Issei, at her home. Cranston Police arrived to 245 Bayview Avenue to check on her well-being. They were granted access from the landlord to the home. Once inside, they noticed signs of a struggle and also located Miss Issei in the bedroom. She was then pronounced dead by members of Cranston Fire Department. Mr. Marapese was located in Cranston a short time later.
I understand there was a statement made to the effect of he was admitting his involvement in this matter. Is that correct?
Yes, Your Honor. He told a friend who called Providence Police through 911. Cranston detectives spoke with that friend and confirmed that information, that Mr. Marapese had told him that he had killed his girlfriend, Lauren Issei.
Do you have an attorney, sir?
No. That's for
You referred to the public defender. The defendant is held without bail. It's been brought to our attention that he is a potential violator on a sentence in Superior Court, so the bail hearing will be transferred to the Superior Court pursuant to Rule 5.
Your Honor, he is also a district court violator.
That will be put down for a status report. He's remanded. He may be taken out directly.
As Marapese was being led out of the courtroom, he allegedly made a threatening remark to Lauren's brother, Ryan Ives, sparking an outburst. Ryan was briefly held in contempt, but later released. Outside the court, Lauren's mother, Cheryl Palazzo, tearfully explained that her daughter had made multiple efforts to seek help, including trying to obtain a restraining order, but the system had failed her. As legal proceedings moved forward, a grand jury formally indicted Marapese in August 2019. He initially pleaded not guilty.
Cranston detectives spoke with that friend and confirmed that information, that Mr. Marapese had told him that he had killed his girlfriend, Lauren Issei.
However, in a major development on July 18, 2025, Marapese changed his plea to guilty. He admitted to first-degree domestic murder involving aggravated battery or torture and also pleaded guilty to being a habitual offender. His sentencing is scheduled for July 31st, 2025. In July 2018, Leah Beatrice Duran, a 41-year-old mother from Woonsocket, Rhode Island, was first arrested at Lincoln Woods State Park after park staff reported that she appeared intoxicated and was attempting to drive away in her minivan with 3 sons and 2 daughters. When officers approached, Duran tried to flee and backed into a law enforcement vehicle. A breathalyzer test revealed her blood alcohol content was more than 3 times the legal limit. She was charged with DUI, operating with a suspended license, and multiple counts of child endangerment. The siblings were safely released to family members, and the Department of Children, Youth and Families, DCYF, was notified. Just 8 days later, on July 19th, Duran was arrested again in Warwick, Rhode Island, after officers observed her driving erratically near Oakland Beach. This time, she had 3 of them with her, 2 daughters and 1 son. She refused a breathalyzer test and was again charged with DUI, refusal to submit to chemical testing, and driving on a suspended license. Due to the repeat nature of the offense and the risk posed to the girls and boys, the judge ordered her held without bail. During her court appearance, Duran became emotional as the judge described her behavior as out of control. The siblings were taken into protective custody by DCYF for their safety. In February 2016, Rochester City Court Judge Leticia Estacio was arrested for driving while intoxicated after police found her in a damaged vehicle on Interstate 490. Later that year, she was convicted and sentenced to a 1-year conditional discharge, which required abstaining from alcohol and installing an ignition interlock device. However, Estacio repeatedly violated the terms of her sentence. She attempted to drive while intoxicated, failed to comply with court-ordered alcohol testing, and left the country for Thailand without notifying the court, leading to the revocation of her discharge. In 2017, she was sentenced to 60 days in jail and placed on probation for 3 years. The misconduct didn't end with her criminal case. Estacio presided over a former client's arraignment without recusing herself and made inappropriate remarks during court proceedings. These actions, along with her ongoing failure to acknowledge the seriousness of her behavior, led the New York State Commission on Judicial Conduct to recommend her removal in 2018. She appealed the decision, but in October of that year, the New York Court of Appeals upheld her removal. As a result, she was officially stripped of her position, ending a 2-year-long controversy that had drawn widespread public and legal criticism. On the evening of July 28, 2018, Dean, Brechet, and a friend named Yolanda went out for a night of socializing that included visiting multiple bars. Although Dean had an early interview the next morning and they had agreed to leave by 1 a.m., the group stayed out well past that time. According to Brechet, she repeatedly asked Dean to head home, but he continued drinking and bar hopping. Eventually, they returned to Dean's car, with Brechet and Yolanda as passengers. Frustration over the delayed departure led to a heated argument between Dean and Brechet while they were still parked.
I know I won't have all of the facts perfectly, but I'm going to try to set the stage of this story so that we can put it in context of what you both want. So I suggest you pay attention to what I'm saying, not look at anything else. You were a couple for a while. You went out for an evening, and and that was on July 29th of 2018. You were driving. And you drove with him. There was nobody else in the car, either going or coming. Is that correct?
That's incorrect.
Who else was in the car? So you went with somebody else who was in the back passenger seat?
Yes, Brechet was next to me.
So it did it happen on the 28th or the 29th?
The event prior was the 28th. My arrest was the 29th.
Got it.
Excuse me.
What?
Sorry, I don't mean to interrupt, but I also want to just make this clear. We were not a couple at the time of the incident.
Just friends?
Yeah.
Absolutely.
Fine. Not easy to do.
No.
You went out for an evening, and the evening was either, I don't care, the 28th or the 29th. And according to both of you, the arrangement was that you would leave this bar that you went to with friends by 1 a.m. because you had an early morning appointment.
That's right. That's true. I had an interview.
So far correct?
Yes.
And then the friend that had come with you didn't want to leave or disappeared. You were looking for her. And that took a little time, so you didn't leave until when you finally found her. She said, I found something interesting here. I think I'm going to stay for a while.
Yes.
Not exactly true. I'm sorry.
No?
Not exactly true. That isn't the exact reason why we left so late.
Why did you leave late?
We left so late because he was still drinking with the other friends that we went out with. And I had asked him to leave earlier about 3 times. And even though he said we would leave, we continued to go around bar hopping. And that is, yes, on my part, partly my fault, because I didn't demand him to leave. At the same time, I came in with him. I didn't have another ride. I should have called like an Uber or a Lyft to take me back home.
But you stayed?
Yes.
And continued to socialize?
Not really.
No, okay. Anyway, you got
But
into the car to go home and you had an argument. And the argument was about the fact that you stayed late?
Yes.
Is that what the argument was about?
I was disappointed, yes.
You were complaining that you stayed late. He was driving.
Yeah.
Now, so I want you to tell me exactly, you're telling him you're annoyed. He says to you, what happened next?
He starts saying, well, it's not my fault that we didn't leave. I understand. I was trying to get her. I should have just left.
Okay.
I tell him, yeah, but you didn't just leave. So he starts saying, he starts saying, you're calling me worthless. You're calling me a worthless man. You're calling me a worthless man.
Just a second. We hopped from, we should have left earlier, to him saying to you, you're calling me a worthless man.
Yeah.
What did you say to him?
I told him, I'm not calling you a worthless man, but I'm saying that I'm disappointed that we didn't leave earlier. You had made a promise to leave.
Just a second. We don't go from, you made a promise to leave, then you're calling me a worthless man.
Because I never said that.
What did you say?
I told him I'm disappointed that you didn't leave when you said that we were going to leave.
And he said, you're calling me a worthless man. Okay, I know you want me to believe that. It's a leap that I'm not here prepared to make. Okay, you're calling me a worthless man, and then what happened?
So he's gesturing with his hands. He talks a lot with his hands.
He can't do this with both hands because...
Well, we hadn't started driving yet. We're still parked. We hadn't started driving yet.
Oh, so you had this argument when you were in the car?
Absolutely.
During the exchange, Bresci told Dean she was disappointed they hadn't left when promised. Dean claimed she insulted him by calling him a worthless man, though Bresci denied making that statement. As the argument escalated, she said she gestured to block Dean's hand and accidentally made contact with his face. Dean interpreted this as an intentional hit and later called the police, leading to Bresci's arrest. The situation was eventually brought before Judge Judy, where both parties shared conflicting versions of events. After reviewing the testimony, the judge concluded there wasn't enough evidence to support Dean's claim of a false arrest. On the evening of June 26, 2025, a call came into 911 reporting a man with a weapon near 25th and Garfield in Milwaukee. Officers Kendall Corder and Christopher McCrae responded to the scene. As they entered a narrow alleyway to investigate, Officer McCrae noticed a flash coming from the bushes, which initially seemed like fireworks, but turned out to be shots being fired. Both officers were hit in what police later described as an ambush. Officer Corder sustained critical injuries and tragically passed away. Officer McCrae was wounded and survived. The investigation quickly led detectives to a backpack left at the scene. Inside, they found identification for 28-year-old Tremaine Jones and a receipt linked to the firearm believed to have been used in the shooting. The next day, June 27th, authorities located and arrested Jones at a home near 37th and Villard.
State of Wisconsin versus Tremaine Jones, case number 25CF3036. Count 1, first-degree intentional homicide, use of a dangerous weapon. Count 2, first-degree intentional homicide, use of a dangerous weapon, attempt. Count 3, first-degree reckless endangering safety, use of a dangerous weapon. This is an initial appearance. This case has been assigned to Judge Havas and Branch 10. Appearances?
Grand Jury for the state. Stephen Sargent for Mr. Jones, President in Court. The address is accurate on the complaint. Phone number for family members 414-218-1909. He qualifies.
I've read the criminal complaint. It does state probable cause. Went over the complaint with him?
Yes.
Waive its reading?
Yes.
Went over his rights and penalties?
Yes.
Status to bill.
Your Honor, first of all, the state will be requesting a no contact order and a no weapons order
I would note that I've already sent that to CCAP. I hope the clerk has gotten it already. Okay, well, I did send it. The no contact order would include all of the named and initialed victims and witnesses that are in the criminal complaint, as well as the two other individuals that are charged, JJK and BT, who are also mentioned in the criminal complaint. Regarding bail, the state is recommending $5 million cash bail. We recommend that based on the serious nature of the offense. In this particular case, the defendant went over to a location with a rifle. He fired into the air. He is alleged, according to the criminal complaint, as witnesses, and fired it into an apartment building. One thing that is not mentioned in the criminal complaint is that there were children in that apartment building and in that apartment. He then goes and waits in bushes, and when two officers go and are just doing their jobs, he opens fire on them. Officer Corder died. Officer McCrae was injured seriously as a result of the serious nature of those offenses, as well as the fact that there is evidence that the defendant attempted to send a witness or send another co-actor to go take the firearm away, which means that he is attempting to get away with this crime. The likelihood that he will not come back to court is very high. The threat to the public is very high. I am recommending $5 million cash bail. I would also note that he does not have much of a criminal record. The only case that we do have resulted in a successful deferred prosecution agreement, or I should say a completed one, because a successful one would mean we wouldn't see him here again. So for those reasons, I am requesting that cash bail. Thank you.
Defense.
Clearly, this is a very serious charge and allegations. My client is a Milwaukee resident, cannot make any significant cash bail. I have nothing further at this point. He has family here. He's worked. He's been employed in the Milwaukee area. Realizing the seriousness of the charges, we'd ask for minimal cash bail.
No monetary recommendation.
Anything beyond a fraction of what the state's recommending is beyond his means.
He was booked on charges including first-degree intentional homicide and attempted homicide. His bond was initially set at $500,000.
You're being ordered to have no contact with JJK. Being ordered to have no contact with BT. The address of 2203 North 25th Street, JDJ, ECT, and DLW. No contact means not in person, not by mail, not by phone, not by third parties, and not by electronic devices. If you can think of a way of contacting those people or that establishment, do not do so. You're also being ordered to cooperate with the Justice Point Pretrial Supervision Program. It will be a TOT with level 5 supervision with court reminders by phone. You're also being ordered not to possess any dangerous weapons during the pendency of this case. Obviously, the allegations in this complaint are very serious. We've had a loss of life and the death of another person. And it could have been much worse because this started off with you allegedly in a building because of some incident between a bunch of parties. You allegedly was called, came back with a weapon, allegedly that weapon in a home with people present, including children. Ran into an alley, hid in some bushes. Is that you allegedly committed cold-blooded murder. Unfortunately, there wasn't 2 lives lost. The case seems to be very strong based on the information in the complaint. And clearly bail, cash bail is appropriate. And I think most people would say it automatically should be set. But I think it's fair for people to understand that a request for $5 million here is what I call a dollar for dollar bail. If $5 million was requested in New York, that would equate to be $500,000. In Chicago, it would be $500,000 because in most places, you could pay 10% of a bail. There's bail bonds, bondsmen. In Wisconsin, we don't have that. And I try to keep that in mind when I set bails. Usually, in homicides, this court sets $100,000 and looks at aggravation and mitigation. In this situation, we do have a lot of aggravation, without a doubt. So a $100,000 bail would not be appropriate. I do not agree that $5 million is, and I hope people understand why with the breakdown I just gave. But I do believe that $500,000 is appropriate. And that's the bail that the court is going to set.
Jones made his first court appearance on July 1st and pleaded not guilty. His preliminary hearing was scheduled for July 9th, but was postponed to July 18th. During that hearing, a veteran homicide detective testified that video surveillance and forensic evidence confirmed Jones opened on the officers. Officer McCrae, still recovering and using a scooter, recounted the moment he heard a man yell threats before shots were fired. After being shot, he crawled to retrieve Officer Corder's weapon in an attempt to protect both of them. Despite his defense attorney's argument that Jones had no prior felony record, the judge found probable cause to bind the case over for trial. The court acknowledged the seriousness of the charges, and the next court date was set for August 6th. In the early hours of June 7, 2025, a quiet Parma neighborhood was disrupted when 2 young men from Valley View, 20-year-old Donald Dika and 21-year-old Jack Clamert, stole one of the city's beloved pink flamingo statues. These flamingos weren't just decorative, they held deep meaning for the community, having been donated by the Vasco family in memory of their daughter with autism. Within an hour, Parma police had identified the suspects using street surveillance and traffic camera footage. The flamingo was eventually recovered, though it returned damaged. The crime, initially charged as a felony theft due to the statue's value, drew public attention and disappointment. On June 24, 2025, the case reached Parma Municipal Court. Standing before Judge Deanna O'Donnell, both Dika and Clamert entered guilty pleas after their charges were reduced from felonies to first-degree misdemeanors.
Present in the courtroom along with their attorneys. All right, gentlemen, you each have a felony charge, a felony of the 5th degree theft. Prosecutor has made a motion. He's going to amend these to a theft charge, misdemeanor of the 1st degree. Because of that amendment, the case now stays in our court. If it were a felony, this court would not have jurisdiction. The case would be going down to the county. Do you understand that, gentlemen? Yes. Sir? Sir? All right. And you're in agreement with that? Because you do have the right to have this case go down to the county in a felony. Would you rather that it stay here? Yes, sir? Yes, sir? Okay. Now, it's the court's understanding that based on this amendment, you now are going to enter a guilty plea to these charges. Is that correct, sir? And sir? All right. I'm going to ask both of you at the same time. Are you presently under the influence of any drug or alcohol? Sir? Has anyone made any threats or promises to you? Do you understand by admitting today you're giving up your constitutional rights to go to trial, to cross-examine witnesses, to summon or subpoena your own witnesses, and to testify on your own behalf if you chose to testify? Do you understand that, sir? The City of Parma does have the burden of proving this case beyond a reasonable doubt by entering the plea today. You're giving up that right. The charge as amended is now a first-degree misdemeanor. The maximum fine and penalty is 6 months in jail and a $1,000 fine. And do you understand that, sir? Sir? All right. You're both represented by counsel. Do you have any questions you'd like to discuss with your attorney before I ask you your plea? No? And gentlemen, you understand everything that I just explained to you? Yes. I'm going to ask you both at this time, what is your plea to this charge, sir?
Guilty.
Sir?
Guilty.
The court will accept the guilty plea, find it to be voluntarily, knowingly made. The court will make a finding of guilt.
The court took note of several mitigating factors. The men had no prior criminal records, paid $2,200 in restitution before the hearing, submitted letters of good character, completed a theft education course, and fully cooperated with authorities from the beginning. In the courtroom, both men issued heartfelt apologies to the Vasco family, the Parma Police Department, and city residents, acknowledging their wrongdoing and expressing remorse for not understanding the full impact of their actions at the time.
Yes, Your Honor. I would like to formally apologize to the Vasco family, all the residents of Parma, the Parma Police Department, and you for this mistake that I've made.
Okay. And sir?
Yes. I would like to apologize to the Vasco family, the residents of Parma, the police department, and Your Honor. We now understand the significance of the Flamingo and the broader implications of our actions. Had we possessed this knowledge at the time, we are confident we would not be in this situation today. Nevertheless, our lack of awareness doesn't excuse our actions. This incident has been a profound learning experience, and we are truly remorseful. We assure you this won't happen again. We also apologize to our family and friends. We could recognize the disappointment and concern we have caused, and we are truly sorry. We've used this time to reflect deeply and understand the seriousness of our actions moving forward. We are dedicated to making better choices and restoring the trust we've lost.
Judge O'Donnell, while recognizing their remorse, reminded the court that adult actions come with adult consequences.
I know that you're not bad men, and I know that you're not evil, and I know that you're not horrible. But you are grown adults, right? You are not kids. And as grown adults, you made a choice, and you chose to do something very foolish and very childish, right? As an aside, do you guys know that there are cameras all over the place, right? Do you know, let me share this with you, big hint, do you know that when you took the Flamingo, the Parma Police Department, they knew within an hour of who you were and where to find you. There are cameras all over the place. That's why I'm kind of amazed that we're standing here on a Flamingo case again. So maybe tell your friends. There are cameras everywhere. Are you challenging the police department? I'm going to bet on them on this one. The truth here is we can tolerate behavior from a child, right? We can tolerate it. But it's really, really hard to tolerate this kind of behavior from adults, from grown adults. And again, despite your lack of knowledge of this Flamingo, and really that doesn't matter. It kind of bothers the court when I hear, well, we didn't know what the meaning was. It was not yours to take. It doesn't matter what the meaning is. It was not yours to take. But now that you do know the meaning, you know that you've hurt a community, you know that you've hurt a neighborhood, you know that you've hurt the residents, and I'm going to say it, you hurt a 4-year-old little girl. And that's something that you have to live with.
She emphasized that the Flamingo was more than property. It represented a family's grief and a city's unity.
There are consequences. You're men, you're adults, you're not children. All right, so let's talk about the consequence here. 180 days in jail. 170 days is suspended. $250 fine. Court costs are imposed. Restitution has been paid. I would have ordered it. You've already done it. Thank you for that. A letter of apology to the city of Parma and its residents and your little girl that you've hurt. Now, I read your apology letter. That's a combined letter. I want a letter of your own individually, okay? Community service, 250 hours of community service. 125 of those hours will be served for the city of Parma in the city of Parma. 125 of those community service hours will be served for the Autism Society of Greater Cleveland. As far as your jail time, when a person goes to jail, the city pays for it, which means the residents pay for it, which means the taxpayers pay for it. That's not going to happen here. The city of Parma will be directed to calculate the cost of confinement, and gentlemen, you will be required to pay that cost. The residents of the city of Parma will not be paying for your behavior. You'll be paying for that. Moms and dads, I know you're in the courtroom. This is your adult children's responsibility, not yours. We do not want your money. We want theirs. Within 30 days of your release from jail, you must pay the cost of your confinement within 30 days. As far as all the other costs and fines, if they need time to pay, I will give them time to pay.
Thank you, Your Honor.
Counsel, do you have any questions for me?
No, Your Honor. Thank you very much.
Gentlemen, do you have any questions for me?
No, Your Honor.
You are on probation. I don't know if I said this. You are on probation to this court for the next 36 months. You have 170 days of jail hanging over your head. If you violate any of the terms of your probation, if you don't do what the court has ordered you to do, you will come back and see me. If you come back and see me, I will put you in jail for 170 days. Gentlemen, that is my promise to you. I keep my promise. I'm assuming your promise to me is that you will never have to step foot in this courtroom again. Right?
Sure.
All right. Gentlemen, you have 10 days of jail to serve. Your jail time starts today.
In her ruling, the judge sentenced each man to 180 days in jail, suspending 170 of those days, and ordered them to immediately serve 10 days. They were also placed on probation for 3 years and assigned 250 hours of community service, half with the City of Parma and half with the Autism Society of Greater Cleveland. Additionally, they were required to pay for the cost of their jail time themselves. Their parents were explicitly told not to cover the expenses, reinforcing the principle of personal accountability. The judge ended with a clear warning. If either man violated the terms of probation, they would be brought back to serve the full remainder of their jail sentence. In the summer of 2023, a relative of Owen from Detroit began to worry after noticing he appeared bruised, underweight, and withdrawn. That family member reported their concerns to Child Protective Services, but the agency allegedly closed the matter without opening a proper investigation. Owen was under the care of Sherman Devon Jones and Sampagita L. Jones, both licensed foster care workers who were also his legal guardians. Over time, Owen became increasingly isolated. Prosecutors say he was homeschooled, kept out of public view, and rarely taken to the doctor. Measures allegedly intended to prevent others from noticing signs of mistreatment. Medical evidence later revealed that Owen had a history of injuries and neglect. When he fell ill with a disease in 2024, his condition worsened over several weeks. Authorities allege the Joneses did not seek medical help despite clear symptoms. On September 19, 2024, emergency responders were called to the home after Owen was found unresponsive. He was rushed to the hospital but could not be saved. The medical examiner concluded that the disease, combined with prolonged neglect, led to his death.
Egregious, Your Honor. This is the type of case that really leaves a pit in your stomach when you think of the unimaginable pain and suffering that was endured by young Owen. The evidence in this case supports that Owen suffered long-term severe physical abuse at the hands of both defendants who were his caregivers at the time. And there's quite a bit of a backstory there as to how the child came into their care, custody, and control, and at which point they no longer had legal authority and legal guardianship, but I will save that for the preliminary exam. Owen was first noticed with physical injuries as early as June of 2023 by a family member of the defendant, Sherman Jones, who contacted CPS and reported her concerns to CPS, and CPS failed to open an appropriate investigation as it relates to that. The medical evidence supports that Owen had scars, scratches, discoloration, and bruising over the entire surfaces of his body, Your Honor, head to toe. In fact, the medical report notes that there are too many scars to count on Owen's body. He was underweight with an extremely protruding stomach. He had healing fractures as well as acute fractures, which means non-healing close in time to his death. Fractures of the ribs, his pelvis, his elbow, scapula, humerus, his hands, his arms. I mean, the list goes on. And again, medical evidence will be provided at the preliminary exam. But what's more, Your Honor, is the evidence supports that Owen was concealed from the world, and the people's position is that was an effort to conceal the obvious signs of Owen's long-term abuse. He was often locked away in his bedroom, not allowed to go outside. He was not taken for normal wellness checks, physicals that children are often taken to. He was homeschooled. And again, it's our position that was in an effort to conceal what would be obvious to anybody else who was living outside of that house. The trauma suffered by Owen made him more susceptible to infection. And when Owen became sick with pneumonia, both defendants ignored his progressive symptoms and illness for weeks and never took him to receive medical care. And again, it's our position that that was also in an effort to conceal the injuries that we know are noted in the medical report and to continue concealing the ongoing severe abuse suffered by Owen. And ultimately, due to the significant long-term trauma Owen suffered at the hands of both defendants, Owen ultimately succumbed to the pneumonia, which would be extremely rare in a child who is healthy and who received appropriate medical care to succumb to pneumonia. And the medical examiner, as a result of the duration in which the medical examiner from his examination opined that this was a homicide due to the duration that these progressive symptoms were ignored. Owen's right lung was compressed because his entire right chest cavity was filled with pus. This child suffered, and he suffered for a long time. And what's interesting, Your Honor, if these two individuals are capable of concealing a child from not only others who might notice the abuse, but ultimately his own mother who was trying to get him back, what's to say they won't conceal themselves from these very, very serious charges? If there was ever a case for remand, Your Honor, this is it, and that's what the people are asking for.
In June 2025, Sherman and Sampaguita Jones were formally charged with felony murder, involuntary manslaughter, and torture. Prosecutors presented a troubling timeline, a year-long pattern of mistreatment, lack of medical care, and deliberate isolation.
Mr. Jones is innocent unless proven guilty beyond a reasonable doubt. These are only allegations. As counsel stated, significant amounts of scientific evidence will come out in the future. If this was a situation where there were exigent circumstances and the necessity for investigation, Child Protective Services did not intervene and did not open an investigation despite a report being made. Additionally, the alleged incident date of this is June 1st of 2023. The warrant wasn't issued until more than 2 years later. I'm stating that these are allegations, that Mr. Jones is employed on a full-time basis, Monday through Friday, from 9 a.m. to 5:30 p.m. He is a holder of a bachelor's degree, and he understands the severity of these charges. We're asking for a personal bond in this matter for the reason that, yes, these are very serious charges. However, this matter dates back 2 years. Mr. Sherman Jones was going to work, living his life, and taking care of his business for a very long time before the state of Michigan sought these charges. He will comply with any conditions of the court. There's no necessity of an electronic tether because he has no criminal history, no pending cases, no contact with the criminal justice system. We're asking for a personal bond in this matter. Thank you, Your Honor, so that Mr. Jones can be released, return to work, and be out to assist with his defense. Thank you, Your Honor.
Judge, these, I'll stress also the obvious notion that these are allegations and that there is a tremendous amount of scientific evidence that is yet to be discovered, and a tremendous amount of scientific evidence that's not been disclosed to the defense. But I'll indicate for the record is that my client is 41 years of age. She has no prior criminal history whatsoever. Ms. Woolmonth was correct that my client is educated. She has a higher education through the University of Wisconsin, 2 years of experience there. And she was previously involved in as a workforce development coordinator at New Foster Care. She's worked with children for virtually her entire adult life without so much as a suggestion that she was an abuser, that she committed acts of abuse. My records reflect that there were no actual investigations conducted by CPS as to Sam Pavito, or Sherman for that matter, but I won't speak to him, that she had never been so much as contacted by CPS, and that she had fostered 2 previous children before fostering Owen. So you take an adult lifetime of fostering children and working with children, and you have no indication whatsoever of abuse, save for, I think, the allegation that's been made by Ms. Woolmonth. I can see that's what her investigation shows. That's her right to indicate that. But you had no indications by any entity that this was taking place with this particular individual, Ms. Sam Pavita Jones. You have here, I think, at least is what I've heard, is there was a medical examination and there was a cause of death that included pneumonia, a clear medical condition. This was not blunt force trauma causing a collapse of some type of internal organ that caused the death. This was pneumonia. Now, I believe the people's theory is that the neglecting care led to this particular child, and God bless Owen, and led to him getting appropriate treatment. I can gather that that's what their theory is, but we don't have that on the record at this point, Your Honor. We have
all of that will come out during testimony at a later date.
It can come out in testimony at a later date. That's a consideration for bond, but we don't have that on this record. To suggest that there are no bond conditions that can be put in place for an individual who has no previous history, who has no history of children, and who has been uniquely in a position to have been around children for her entire adult life, I think is inappropriate. I think that a cash bond in the area of $100,000, perhaps with a 10% provision, with a GPS tether, is a sufficient condition that can satisfy both the safety of the community and my client's return to court. My client has been aware of this particular investigation since she called 911 and then was ultimately taken over to headquarters to speak with law enforcement. She sat down with law enforcement when the tables turned and she felt like she might need to have an attorney present. She invoked, as is her right, retained counsel. But you know where she's been since? In the state of Michigan. If she wanted to flee or if she had any intention to do so, she would have left. She's been here. So to suggest that she is a flight risk or that there aren't conditions that can be set.
No, let me clarify for the record. I don't think either Mr. and Mrs. Jones are flight risk.
Thank you.
Okay.
To suggest that there aren't conditions that can satisfy.
Defense attorneys argued their clients had no prior criminal records and emphasized that these were still allegations.
Given eloquent arguments in this matter, this is an unfortunate situation, and it's very, very rare before the court that I see such egregious and horrendous allegations. I've been practicing law for quite a while, but every so often these cases kind of touch your emotions, and this is one of those cases. If the allegations are true, and I can see both parties are presumed innocent until proven guilty, at the very, very best or worst, or whatever you want to call it, this is extreme neglect that led to a child's death. Or the other way to look at it is that it was just egregious enough that if this was neglect to the point of intentional homicide. The fact that the child was homeschooled, allegations of neglect to seeking medical treatment, and the fact that the medical exams report indicated the child died of pneumonia, all point toward extreme neglect or callous indifference toward the child's well-being. If the allegations are true that his physical condition was such to the point that is described by Madam Prosecutor, then it stands to reason, and I did not go to medical school, but I've had pneumonia before, that your immune system, even for an 8 to 9 year old, even for that matter, even an adult, is very, very weakened. And that under normal circumstances, people do not succumb to pneumonia. But if the allegations are true that the abuse was such to that extent, then there's no doubt in my mind that the immune system would be weakened and would be vulnerable to a cold, pneumonia, or anything like that, that a person with normal immune systems and normal health would bounce back from. That's not unsurprising to the court. I find that these allegations are in fact true. This is egregious, and under MCR 6.106, the presumption of guilt has been met here under that court rule in this matter. And I'm going to remand both Mr. and Mrs. Jones in the custody of Wayne County Jail while this case is pending. This is very, very troubling. The court is very, very emotional on so many different sides in this matter. Probable cause, July 3rd, preliminary examination, July 10th, both defendant Judge Jack K. Is there anything else either counsel wants to put on the record? Starting with you, Madam Prosecutor.
I have nothing further at this time, Your Honor. Thank you.
Despite those arguments, the judge found the accusations serious enough to order both defendants held in jail without bond. A preliminary hearing has been scheduled. The case has drawn widespread concern and criticism of the systems that failed to protect Owen. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.